Multiple lower courts have already ruled that Trump himself did personally engage in insurrection. But a core question at issue here is for whom this insurrection clause was really intended. Which offices count? Which officers count? Was it intended for presidents and presidential candidates, or are they somehow exempted? Now, the Colorado Supreme Court, state Supreme Court, goes a long way towards resolving what the authors of this amendment were thinking about when they wrote this, whether they specifically intended this amendment, this Section 3 of this amendment, as a guardrail against presidents and potential presidents who engaged in insurrection. The state Supreme Court did some very, very deep research to make the case that, yes, this sure does apply to presidents and presidential candidates. And to that end, among the best and deepest cuts cited in this ruling is this one. It is a conversation between two senators in the year 1866 as they were literally writing the 14th Amendment. Senator Reverdy Johnson worried that the final version of Section 3 did not include the office of the presidency. He stated, this amendment does not go far enough because past rebels may be elected president or vice president of the United States. So he asked, why did you omit to exclude them? I do not understand them to be excluded from the privilege of holding the two highest offices in the gift of the nation. Senator Lot Morrill fielded this objection. He replied, let me call the senator's attention to the words, or hold any office, civil or military, under the United States. This answer satisfied Senator Johnson, who stated, perhaps I am wrong as to the exclusion from the presidency. No doubt I am. The senators who literally wrote the 14th Amendment specifically meant for it to apply to the presidency. It does not get any more originalist than that, my friends, and that is exactly the point here. Adam Serwer argues in The Atlantic today that this ruling from the Colorado State Supreme Court is going to put the court's conservatives between a rock and a hard place. The court's conservative justices often justify their decisions through the legal philosophy of originalism, or trying to interpret what the founders meant when they wrote the Constitution. Serwer writes that this Colorado Supreme Court ruling is calling the bluff of the U.S. Supreme Court's originalists, forcing its conservative justices to choose between their purported legal philosophy and the partisan interests of the party with which they identify. So it would seem. Now, Trump has until January 4th to appeal the Colorado State Supreme Court decision, and his campaign says it plans to. And when that happens, it will put the issue on hold until the Supreme Court makes its decision, meaning Trump will likely be on the Colorado Republican primary ballot, but whether he appears on the general election ballot in Colorado and potentially in any other states that could follow Colorado's lead, all of that will rest once again in the hands of the Supreme Court.